Good morning. The subcommittee will come to order. Without objection, the chair is authorized to declare recess at any time. We welcome everyone to today's hearing on the Foreign Intelligence Surveillance Act, FISA. I will now recognize myself for an opening statement. Again, I welcome my colleagues. Thank you for being here. We're trying to beat a vote time, so we want to get as much done as we possibly can before that is called. If we're not finished, I'll let you know that we're planning on coming back following the vote series if we still are engaged here. I thank our witnesses very much for being here. Appreciate you being here as well. Congress enacted the Foreign Intelligence Surveillance Act in 1978 in response to revelations that the federal government had seriously abused warrantless surveillance, resulting in rampant privacy violations. 45 years later, the same remains true. Despite efforts to rein in these abuses, the federal government continues to use its powers to illegally spy on American citizens. The federal government uses your tax dollars to spy on you using a law called the Foreign Intelligence Surveillance Act, or FISA. In 2019, Inspector General Michael Horowitz exposed the extent to which the FBI violated its authorities under FISA. IG Horowitz identified significant concerns and serious performance failures, including numerous factual misstatements and omissions in the FBI's unjustified investigation of Trump campaign associates. In 29 applications that the FBI made to the FISA court to authorize surveillance, IG Horowitz found in 25 of them there was unsupported, uncorroborated, or inconsistent information, totaling more than 200 instances where the applications were inaccurate, unsupported, or omitted information. The FBI was unable to even locate the Woods file, for the other 4 applications. So the 29 couldn't even find 4 Woods files, and found over 400 instances of noncompliance with Woods procedures across the 29 application sample. In February 2020, Director Wray testified before this committee and told the American people that they should not, quote, lose any sleep over the vast majority of FISA applications. Former Director Comey labeled FISA a top-tier FBI program, but upon further review by the Inspector General, it was revealed that the FBI failed to recognize the significant risk posed by the systemic noncompliance with the Woods procedures, which provide the factual justification for FISA applications. In May of this year, Special Counsel John Durham released his report on the FBI's Crossfire Hurricane investigation. That report not only backed up Inspector General Horowitz's findings, but also found that political and confirmation bias by FBI employees led the FBI to lie to the Foreign Intelligence Surveillance Court and illegally spy on the Trump campaign for an entire year. In the recent investigation of Special Counsel Durham, he found that some FISA applications ultimately arose from sources close with the Kremlin, who were known to be targets of ongoing U.S. investigations related to fraud and espionage. Durham concluded that the FBI ran with the first justification it found to spy on the Trump campaign, despite clear indications of foreign, unreliable sourcing. These reports detail only a fraction of the government's abuses of the FISA program. At the end of this year, Section 702 of FISA will expire. Section 702 does not require a warrant or any other justification to an independent arbiter, such as a judge or magistrate, before the government agent can query databases about an individual who is a U.S. citizen. Reports in recent years have exposed the government's and specifically the FBI's abuse of this program. A law designed to provide tools to collect foreign intelligence and prevent terrorist attacks has been warped into a domestic spy tool that has been used millions of times over the past 3 years to target Americans. In 2021, the FBI queried the communications of over more than 3.3 million times, and of more than 1 million discrete U.S. citizens. In 2022, the FBI conducted thousands of U.S. person queries. A recent FISA court opinion revealed that the FBI conducted more than 278,000 improper searches of U.S. persons' communications in 2022, including those of people who attended protests, 19,000 donors to a congressional campaign, and in another instance, the FBI looked at the communications of donors Think about that. 19,000 people on a donor list are being queried and looked at by the FBI simply because they did donate. As Congress considers whether to reauthorize this program, this committee will be at the forefront and has the opportunity to shed a light on the broad issue of warrantless mass surveillance in violation of the Fourth Amendment. We must consider whether FISA and Section 702 can be reformed or if it's beyond repair. I, for one, see no reason for members on either side of the aisle to trust the FBI with this tool. The FBI has used FISA, specifically Section 702, to spy on Americans, to violate the Fourth Amendment and conduct warrantless searches. FISA 702, let's see here. It's clear that the government is using communications acquired through this program to conduct backdoor searches, which I think we'll hear more about today. Most of this is done without a warrant. Section 702 information acquired without a warrant can later be used by the FBI in criminal prosecutions unrelated to foreign intelligence or national security. The FBI has misused privileged spying powers to conduct rogue surveillance on innocent Americans, and we cannot allow that to continue. I have called for serious reforms or full repeal of FISA for years. I think it is built on a dubious constitutional foundation. The FBI has used this tool designed for foreign surveillance to spy on congressional donors, January 6 protesters, Black Lives Matter protesters, and even elected officials, including one of our own congressional colleagues. We must end warrantless surveillance of Americans and hold accountable any federal official who violates the civil liberties of Americans. Make no mistake, actors within the FBI and other similar federal agencies who continue to conduct unlawful and unconstitutional surveillance of Americans should be brought to justice. Some argue that these are no more invasive than a stop and frisk Terry stop, but at least in a stop and frisk, you have personal contact and actual communication between the target and the government agent. I suggest that even a 702 query is more akin to a wiretap, which requires a warrant before executing that query or that wiretap. The FBI claim now is that it's okay because it has put in place new protocols and new software. But unlike a warrant, all of the FBI measures rest ultimately on post-action review, and it's not by an independent arbiter. I continue to believe that we will be able to work across the aisle with our colleagues because so many of us agree on this issue, and I extend my hand to them and look forward to working with Ranking Member Jackson Lee and other members of this committee as we confront this serious issue. Again, I thank those on the panel for being here today. I thank our witnesses and those in the audience, and I yield back and now recognize the Ranking Member, Ms. Jackson Lee, for an opening statement.
Mr. Chairman, thank you so very much. I am very pleased to join you in convening today's hearing on the Foreign Intelligence Surveillance Act, or FISA. As I indicated during part one of our examination of FISA, this subcommittee has a critical role to play in the reauthorization of Section 702, which expires in less than 6 months. Let me acknowledge all of my colleagues that are present here today, in particular, Ranking Member Nadler. The two of us may be the only ones present that were here when the Judiciary Committee single-handedly had to put a pause on the Patriot Act and begin to address some of our concerns after 9/11. Even in that dastardly, devastating loss of life, it was important to recognize that we are a nation of laws and the Constitution, and to be able to respond at that time. I know that the thousands of agents across America have as their general premise to investigate crimes and as FBI agents, and to follow the law and to protect the American people. That I will acknowledge. We had the opportunity to be briefed just a few days ago by members of the FBI, and I will acknowledge that there is a critical understanding of the challenges that we are now facing. But Congress is the arbiter of the Constitution, and the responder to the American people and the protector of the American people's constitutional rights. With that in mind, this vital set of provisions under Section 702, which has been the subject of much scrutiny and criticism, permits the federal government to collect foreign intelligence targeting non-U.S. persons outside the United States without obtaining individualized orders. It is, of course, a unique provision. While I expect that today's witnesses will discuss many of those criticisms, I hope that we're able to have a constructive conversation about the ways in which Congress can make certain that U.S. persons are not ensnared in the web of international surveillance. I will look forward to their insight because we will act. Congress must act. Beginning with the Foreign Intelligence Surveillance Act, which first passed more than 30 years ago to address abuses in collecting and using foreign and domestic intelligence, the government must show not only that there is probable cause to believe the target of intelligence surveillance is an agent of a foreign power, but also that foreign intelligence gathering is the primary purpose of the collection. Following the 9/11 attack and significant advancements in technology, the foreign intelligence gathering needs of the country shifted considerably, yet were often stymied by the need to obtain individual FISA court orders for overseas surveillance, which requires substantial manpower as presented to Congress by law enforcement. In response, Congress passed the FISA Amendment Act, FAA, of 2008 that authorized the federal government to collect massive amounts of information through the targeted surveillance of foreign persons reasonably believed to be outside of the United States without a warrant. Congress has granted agencies within the U.S. intelligence community this authority through FISA and Section 702 so that they may gather foreign intelligence information to seek out, pursue, and thwart threats from foreign terrorists and nation states that mean to harm us. Together, these statutes have been vital to the protection and safety of Americans. However, as we consider reauthorization of Section 702, we must be certain that we are not conceding very clear the constitutional rights of Americans in the name of national security. That is what makes America unique. That is what is the grounding of the constitutional pillars that are our definition. The FAA requires intelligence agencies to design targeting procedures to limit the scope of collection before the government acts, and minimization procedures to limit the use of information about U.S. persons after the government incidentally collects that information. The Foreign Intelligence Surveillance Court reviews these procedures for legal sufficiency. Although the statute includes protections for U.S. persons whose information is inadvertently collected but not constitutionally subject to targeting, we know that the NSA and DOJ have repeatedly reported the unauthorized use of backdoor searches of the 702 database. And as a release from the Brennan Center pointed out, internal oversight measures hailed as robust failed to prevent flagrant abuses, including 133 warrantless searches aimed at Black Lives Matter protesters and 19,000 searches for communications to a single congressional campaign. We're also faced with considering what guardrails are appropriate to prevent federal agencies from evading the legal protections of Americans' privacy by purchasing data from data brokers. These and other problems with FISA and Section 702 have led some of my colleagues, particularly Chairman Jordan and Chairman Biggs, and all of us, to take a position adverse to reauthorization of Section 702 in its current form. Since this is the second hearing of this subject, I hope that my colleagues are attaining sufficient information to help us reach a compromise position to move this reauthorization forward and to acknowledge that all of us have criticisms, but I think what is broken needs to be fixed. Given the threats facing our nation from the ruling Chinese Communist Party that represents both the leading and most consequential threat to U.S. national security and leadership globally, according to Director of National Intelligence Avril Haines, to terrorist groups such as ISIS, Al-Qaeda, and Hezbollah that continue to plot attacks against the United States, it is critical that we take appropriate action before the expiration of government authorities under this provision and simply make it right, make it correct, make it constitutionally infrastructured, if you will, to be able to function for what it is needed and to protect the American people. That is why I will reiterate my thoughts from part one of this conversation, we worked together to pass USA Freedom Act in 2015, demonstrating that we're capable of building consensus around our common values, dedicated to privacy, transparency, and protection from unreasonable searches and seizures. Let us do so again together on behalf of the American people, reshaping these critical tools so that they serve the government's needs while also protecting the privacy of every American. I look forward to the testimony of our witnesses and yield back, Mr. Chairman.
Thank you. I thank the Ranking Member Jackson Lee. And now the Ranking Member of the entire committee, Mr. Nadler from New York.
Thank you, Mr. Chairman, and thank you for continuing this committee's important work on FISA reauthorization and on the overall question of the warrantless acquisition of U.S. person information. At our last hearing, we heard from government watchdogs who described the FBI's ongoing compliance issues with Section 702. Today, I hope to hear from the witnesses about the impact of these violations, even when they are unintentional, and about what changes this panel believes would make inappropriate queries of the 702 database all but impossible. As I said at the beginning of our last hearing on this topic, I have never voted to reauthorize Section 702. I am deeply uncomfortable, as we all should be, with the legal fiction that it is permissible for the government to search our most private communications without a warrant simply because they were aiming for non-U.S. persons overseas. I understand, however, that this authority has become increasingly important to our national security, and so I will entertain reauthorizing Section 702, provided that we meet this basic privacy challenge head-on. Although Section 702 authorizes only the targeting of non-U.S. persons who are outside the United States, we know that massive amounts of U.S. person data are swept up under this programmatic surveillance. We also know from what reporting is available that the government has a lot of this data, that much of it could not have been obtained without a warrant had they tried to collect it directly. As the reauthorization debate has begun in earnest, the FBI has assured us that they only receive a small percentage of the total information collection under Section 702. We cannot discuss precise numbers in this setting, but nobody should take comfort in the fact that the FBI only has access to some portion of a staggeringly large volume of information, including vast amounts of data about U.S. persons. The FBI has also demonstrated, after 2 decades of tinkering with the system, that improved training and the reconfiguration of their database has reduced the number of improper queries of Section 702 information by roughly 90% this past year alone. That is no small feat, and I wonder where this debate would be today if the Department of Justice and the FBI had taken their noncompliance problems seriously years ago. But again, it is difficult to find comfort in the percentages. If 2 years ago there were 2 million improper queries, and last year there were only 200,000 improper queries, we are still left to contend with 200,000 unsuccessful attempts to sidestep our constitutional protections. In a recent briefing, the FBI and the Department of Justice told our members and our staff that one cause of noncompliance was a simple misunderstanding, in quotes, of the legal standards under Section 702. That was their term, misunderstanding. I have no doubt that FBI personnel and field officers across the country may have had trouble interpreting the law, and I am pleased that the administration has corrected course, but I find it deeply troubling that the FBI would blame its field officers for a problem that clearly originated from its leadership. Let's tell the story as it actually happened. Congress last reauthorized Section 702 in 2017. Over the course of the next few years, DOJ and the FBI diverged on how to interpret the legal standards for searching the Section 702 database. The FBI told us at the time that it was perfectly appropriate for the Bureau to take a looser view of the statute, an approach that ultimately gave them more access to our private communications. This was no misunderstanding. It was a deliberately maximalist interpretation of the law. The scathing FISA court opinion that has been released since our last hearing, the one that showed the FBI querying the database for particular campaign donors, George Floyd protesters, and January 6 suspects, is a direct rebuke of that interpretation. I understand that the FBI has since corrected course. I'm deeply gratified that the leadership of the Department of Justice took control and decided to adhere to the limits Congress put in place. But this so-called misunderstanding really gets to the heart of the matter. Chairman Biggs and I agree on very little. But here is one place we agree. Whatever we think of the last administration, whatever we think of the current administration, we cannot count on the next administration to get this right. We have to build a Section 702 regime that fully respects our privacy, no matter who is in charge. Not 90% of our privacy, all of our privacy. The changes the FBI has made to this program in the run-up to reauthorization are welcome, but they are insufficient. I look forward to hearing from our panel today about what else we must do to correct this program before it can be reauthorized. Thank you, Mr. Chairman, and I yield.